Good morning, good morning, good morning.
Morning.
Let's wait on a few others. There's 3 on now, so let's see. Who else is coming?
Can you hear me?
Yes, I can hear what you said.
Okay, I was just checking to see if my mic was working.
Yeah, working. It's working. We give them 5 more minutes. All right, so we're ready to start. Did everyone read the chapter on breach of trust? Yes, no, maybe so.
Good morning. I started to read a little bit of it.
Say a little bit.
Mom is not trying to lie. Times I knock off from work, it's very tiring. And I know I was reading the pages. The next thing I know, that was it.
The pages was reading you.
The pages was reading me all this week. I was just reading every day. Work, book.
Oh, Lord. Sorry to hear that. I'm so sorry to hear that.
No problem.
Anyhow. Okay, so let's start. So we know in order for there to be a breach of trust, there must be something that the trustee would have done that he ought not have done.
Yes,
So
ma'am.
normally when you speak about breach of trust, you're talking about the trustee not following one of his duties. So remember I told you, or when I started, that you must know all of the duties of a trustee in order to be able to determine if there was a breach of trust. So you know off the top of your head that a trustee has a duty of care. And he has to make sure he carried out all his duties and his responsibilities as he's supposed to in administering the trust, which means he has to do that in accordance with the trust deed, in accordance with the law, and he must also make sure that he acts honestly and in good faith. And then also ensuring that he provides the information to the beneficiaries when requested, which is the financial information. But on the opposite side, like we learned in the last class, the beneficiaries have an equitable interest in the trust. So by them being an equitable owner, they can bring a claim against the trustees if they feel that there was a breach of trust. And they know that the trustees owe them a duty as the beneficiaries. So in order for them to bring a breach of trust, a beneficiary has to prove that the trustee did something that he should not have done. So when you look at, if you want to claim that a trustee has breached his duty, then the beneficiary can do so, and he can claim for damages. And the damages he sued for is the same damages that would be as if a regular person like you or I had a contract. So even though the compensation for breach of trust is an equitable claim, because remember now the beneficiary has an equitable interest in the assets of the trust, it is the same as damages that is awarded to a regular person. So the measure of liability, I mean, how much the beneficiary should receive for the breach is the loss, direct or indirect, that is caused to the trust. So it's normally a sum of money. And of course, the beneficiary has to be able to establish that there's a link between the actions that the trustee took and the loss that was suffered. So when you talk about a breach of trust, there are different classifications of breaches. So breaches can be serious, and then there are some that they call innocent. So serious breach of trust I've listed below. I gave you examples. When the trustee wrongfully distributes income or capital to a trustee, or he does not exercise his discretion properly, he distributes the income or capital. He does not distribute the income or capital as required by the terms of the trust. He doesn't select or supervise agents properly. He misappropriates the trust funds for a trustee's personal expense, or he fails to obtain the relevant consent that's in the trust deed. You know, normally the trustee would say, obtain the consent of the beneficiaries or obtain the consent of the protector. So he didn't obtain those. He purchases trust property without authorization from the trust or beneficiaries or the protector. He profits from the trust, which you know is not lawful. Or he invests trust funds in unauthorized or unsuitable investments. And you know that from when we did the investment chapter, that you have to actually have an objective and a strategy, and it has to fall within the terms of the trust deed. And of course, is a breach if he fails to account to the beneficiaries. So when this happens, there are remedies available to the beneficiaries for breach. They can sue for injunction. They can bring an action against the trustee for the loss suffered, or they can go and ask for recovery of the trust property. That means go behind the person to whom the trustee sold it to, and they can bring an action against those who have received the property. So they could actually bring an action against the person who's holding the trust property.
Ms. Archer.
Go ahead.
Okay, in the wrongful distribution of income or capital by a trustee, or the incorrect exercise of a trustee's discretion, how do they prove that if the trust is at the discretion of the trustee?
That's a very good question, you know. Because he's exercising his discretion.
And the person and the beneficiaries do not have access to the minutes of and what they would have used to make those decisions. So how do they prove that?
I'm trying to see if I could recall a case where they didn't
I can
exercise.
understand and not distributing the income or capital as required by the terms of the trust, because that would be written in the trust document. So as long as the beneficiary didn't receive what they should have gotten it in the way they should have gotten it, then yes, they could prove that one more so. But the distribution, how do you prove that?
Okay, let me see this one. Let me see if this case look like. It says equitable rule, all trustees liable for loss must bear the loss equally. Okay. If one has been called upon to pay more than his share, no, that won't help. I'm trying to see if I have a case or there's a case close. I'm sure there is, because just by them saying, giving these examples, there have to be cases that's rare. Yeah, that's relevant to it.
Be one.
Yeah, there has to be one. I'm trying to see if they mentioned an actual case to do with that. No, let me see. It's probably very old too.
So it's probably one that doesn't hardly come before a court then.
Yeah, they said that it's very rare to have a trustee who doesn't do anything wrong. This is very rare. They say most of them are normally minor or technical, but not really ones that are that bad. Let me see what this one is. Investing trust funds. I'm trying to see some cases here. Let me see. Some of these are very old.
I also have another question.
Okay, hold on with that one. I'm trying to find a case for you.
Yeah.
Because it's a good question, but normally they need the cases they give are not that many. Okay, the judicious breach of trust. 2 and 3. Okay, so I see they give me an example of where the trustees applied for an injunction to restrain a sale of trust property for a price lower than that offered by a prospective purchaser. So that won't be it. Next case is to restrain trustees for distributing an estate contrary to the provisions of the trust instrument. So it won't be that. Next one is from selling land held upon trust for sale without appointing a second trustee and without consulting the beneficiaries, and it won't be that. And then they move on to personal liability. Let me see. It could be in one of these with personal liability, you know. But then all they're saying, there was a personal liability and not given the details of what they did. Co-trustee, no. Could be any one of these. Let me see. Oh, guess what? I'm here thinking and rocking my brain. I do know one.
Would probably be a case that does not have discretion then?
It did have discretion in it. It did. It did. Hold on, where I put my paper. It did have discretion. There's one. There was one. And in this case, the principle they used was a retiring trustee remains liable for any breaches committed by him during his tenure of office, but he is not liable for breaches by his successors, unless when he retired with knowledge that a particular breach was likely to take place after his retirement. See, they all link in, like you can't like separate it. So there was a breach that occurred, and that breach was known to that retiring trustee. He knew that that breach was going to continue. So now what was that breach? And when you read the case of Head versus Gould, it refers to the trustee not exercising his discretion properly. So look the case up. Head versus Gould.
Okay.
1896. You'll see it again. That's why I hit myself in my head.
Okay.
Everybody else got that little hint, right?
Head versus Gould.
Gould, G-O-U-L-D.
And the year is 1886?
96.
1896.
1896, 2 Chancery, page 250.
My second question was, when the beneficiaries decide to sue in a case like, say that they did not distribute, or they didn't, like, say the trustee didn't invest when they should have or how they should have.
Uh-huh.
And they're suing for loss of income or, to the trust. How is the compensation for that? Because how do you determine what you would have gained as the income if they had invested?
Well, that's 2 calculations, One calculation is what is the loss based upon what they did. And then the other calculation is if they had invested and what they should have invested in. Any investment manager be able to tell you, if you had invested at this time, this is what it should be. It's just a calculation.
Okay.
Okay. So that comes more to what you call like the award of liability.
Right, but first they have to prove that it was a breach. That
Right.
They love But the thing is, hindsight is always 2020. At the time, they would not have known that they would have gained this or that if they had invested, because maybe they invested in something more safe.
But that's true too. But don't forget now, if the trustee can prove that what he did was honest and in good faith, and at that time in the best interest of the trust, then the beneficiary will not be able to prove that there actually was a breach.
Okay.
Yeah, because you have to be able to prove that not only that you made a loss, but that the decision that the trustee made was not in the best interest of the trust, and that he didn't exercise his discretion properly. So then you'll have to also prove that whatever information he relied on was not the most accurate information, that he didn't do his work, his homework, and figuring out which investment to continue in, which one to sell, whether it would meet the income, whether it would benefit the capital beneficiary.
Because they're not supposed to invest in risky investments, eh?
Exactly.
Okay.
So Normally they say that the rules relating to the measure of liability for a breach of trust in relation to investments is one. If a trustee makes an unauthorized investment, he will be liable for any loss incurred. That's the first thing. The second thing, if a trustee improperly retains an unauthorized investment, he is liable for the difference between the price which he eventually sold it for and the price which would have been obtained if it had been sold at the proper time. You get that?
Yes.
Okay. And then the third one is if a trustee improperly sells authorized investments, he has to replace it. Or he has to pay the difference between the price received and the cost of replacing it. So let's say he had an authorized investment, he sold it, and then he reinvested it in unauthorized investment. The trustee is liable for the difference between the amount yielded by the unauthorized investment and the amount which would have been received if the authorized securities had been retained. So that's how they measure the liability. So that's why it's always good just to follow the trust deed and the law of the trust. And when you're in question, you go to the court. So the beneficiaries can bring an action for injunction to restrain the breach by the trustee. And that's in the case of Bootle versus Sanders. Injunction was granted to restrain a sale of trust property for a lower price than that was offered by a prospective purchaser. And then in Fox, the court granted an injunction to restrain the trustees from distributing an estate contrary to the provision of the trust deed. So the main remedy commonly used by beneficiaries who are aggrieved is to sue the trustees personally for any loss to the trust caused by the breach of trust. And an action against a trustee for loss suffered due to a breach of trust is normally a personal one. And the legal remedy must be pursued before you can do any proprietary remedy can be made to the court. So a trustee is only liable for his own breaches and not for his co-owners. But he can be liable in default if he himself allowed the breach to occur or he was not supervising his co-trustee. So that was seen in the case of Bain and Hughes, where the trustee allowed a matter to remain in the hands of a co-trustee without inquiry. And always remember, in employment law, you have vicarious liability. You know what vicarious liability means?
No, ma'am.
Okay, vicarious liability means that employment means that when an employee is out driving a car and they hit someone else or knock someone down, that person or the family of that person can sue not only the employee who is driving, but also the company. In trust law, there is no vicarious liability.
Pronounce the price word for that, please.
Vicarious, V-I-C-A-R-I-O-U-S.
Oh.
Yes, you have that in employment law.
So that is to say that the onus doesn't transfer over to the company. It sticks with the person who is in the accident.
No.
No vicarious liability.
In trust law, don't forget now, in trust law, you only have trustees and co-trustees.
Mm-hmm.
And that's why they're saying there's no vicarious liability. Because when the beneficiary brings a claim of breach of trust, it's against a beneficiary. I mean, it's against a trustee, not all the trustees.
So it doesn't automatically transfer over to all of the trustees?
No. They'll have to prove first that all of them were in it together. or one trustee didn't do what he was supposed to do in relation to the other trustees. But always remember that all trustees, when there's a breach, they're all liable. Because liability for trusts is joint and several. So joint and several means that you can do one trustee, you can do two trustees, you can do three trustees, you can do four trustees. It's joint and several. But
And that is because
go
they're
ahead.
supposed to be monitoring each other.
Yes. And you're not supposed to do follow behind every trustee. You have to make your own decision. And even though the trustees could be joint and several, there could be instances where one trustee loss or their breach is greater than the other ones. And then what the court will do is they will split the loss between them in order to claim from each one of the trustees. So, normally like in the Bahamas, there's only one trustee. Once someone contracts with a trust company, usually it's just that company is the trustee. And then a trustee is not liable for breaches that were committed before they took up the appointment. But he can only use that as his defense if he did what he was supposed to do when he took on a trust. Remember, he has to familiarize himself with it. He has to make sure that the trust documents were properly transferred. He has to look at the books of the accounts. He has to see who the beneficiaries are. See if the latest amendments have been done to the trust deed. All those things he's supposed to do.
So basically, if he noticed that there was a breach in the trust, when he's taking over, he's supposed to rattle the rest of the trustees, then, eh?
Yes, he has to then state what the plan is to correct that defect.
So what if they decide to correct it versus bringing it to light to the beneficiary? Is that an option?
It depends whether it's major or minor. If it's minor, just a technical, then probably not. But if it is going to be whereby there is a loss incurred, your best instance would be to tell the beneficiaries. Don't forget that you can always go to the court if you're not sure if it's minor. But whenever you're going to incur a loss, and if that loss is a major figure, you need to let the beneficiaries know. Because he has a duty to the trust to address whatever he sees is not right.
So this is the type of instance where it would have been, where it says the wrongful distribution of income or capital by a trustee.
Yes.
So if the trustee is one who's retiring and the new trustee is stepping in, and the new trustee notices that they distributed the income and capital based on the trustee liking one of the beneficiaries more, so they gave one of the beneficiaries more funds, that being the breach, then that would be a case where this would be the situation then.
Yes.
Okay.
So a retiring trustee also remains liable for any breaches that were committed during their tenure in office. And he is not liable for breaches that happened after he left, unless he knew that at the time when he was leaving, the breach was likely to occur. And that again was seen in the case of Head versus Gould. So that case of Head versus Gould speaks about retiring trustees. It speaks about distribution of income and capital incorrect exercise of trustee discretion, all of those. So that's the case that you should read. You don't think so?
Yes, Mom.
Yeah, you should read that one. Now, on the other side of it, for a trustee, he can insure himself against liability, but he can't. But it doesn't include breach of trust. And the Trustee Act itself gives a trustee some protection for loss suffered due to the agents or their actions against certain conditions. But again, they have to be acting honestly, reasonably, and in good faith. So sometimes when a trustee is liable for breach of trust, he can seek indemnification by the beneficiaries themselves. Then he may have gotten permission from some of the beneficiaries who participated in the breach. So all of this has to be brought to the beneficiary's attention. Now, normally when you talk about breach of trust, it goes even deeper than this, but to go deeper, there's a lot of cases you will have to read. So that's why we just shortened this so you can get a snapshot of how breaches take place. And for you to just read the few cases that are here. So I can ask you some questions now. What should a trustee do if he's going to carry out an act beyond his authority? What should a trustee do if he's going to carry out an act beyond his authority?
You should go to the courts first, eh?
Yes, he should. Yes, he should. That's the first thing he needs to do is go to the courts. Everybody got that?
Could you repeat that again?
I asked you, what should a trustee do if he is going to carry out an act that goes beyond his authority?
Okay.
You're welcome. Good morning. He should seek legal advice.
No, go to the court. Let's go to the court.
To get the court
That's what he wants.
approval.
Yes. He has to go to the court. Don't forget now, he would seek legal advice if he was employing an agent, or maybe he was needed some tax advice. In those kind of instances, he would go to a lawyer. But when you're talking about a trustee exercising his discretion, he's going to go to the court.
Excuse me, Ms. Archer. So in that case, he wouldn't just go into the protector wouldn't help?
No, the protector's role is to make sure that the trustee is doing what he's supposed to do. From a trustee perspective, he goes to the protector if the trustee says, when distributing or I don't know, when selecting a trustee, you have to seek the consent of the truster, of the protector. So really, only thing the trustee goes to the protector for is one. He may go to him for personal information on the beneficiaries. Two, he may go to him if he wants some idea of how
the beneficiary is, that the person he is.
Yeah, what kind of person the person is, or he may want to say, in the settlor is now dead. He had made this provision to give this beneficiary this at that age. The person is not going to be doing medicine anymore. The person wants to do something else. Do you think that the beneficiary would have had any objections to this? That's what they ask them for. They're like a sounding board.
Oh,
yeah.
Thank you.
All right. So my next question is, what are the defenses available to a trustee?
One would also be the courts, eh?
As a defense?
I mean, going to the courts, the law. The
Don't
fact that
forget now.
the
Okay,
trust
so
deed, because he can use the trust deed to prove that he is operating trust deed. If the trust deed is giving authorization as to have discretion, or he can, he can prove that he is doing what was in there.
okay. So he can go first defenses, he can go to the courts to relieve him from breach or from any liability because of the breach. So that's the first one. You have any case you could think of? So that's one defense. What's the section to go to the court? If you wanted to go to the court, what section is that? In the Trustee Act.
The section 32?
No, you too low, too low.
Is it section 23?
What 23 says? I know that too low. What 23 says?
23 is where they can insure themselves against liability, or they can have insurance.
They can insure themselves against liability, but not breach of trust. So that doesn't help them. You want the section that refers to where they can go to the court.
Is it section 35?
Where are you in 35? Let me see what 35 says. Exoneration of trustees. No, that's power of attorney. You all gave me that the last time. No, you all like that section. I don't know why. Okay, so there's two sections you could use. One is the section where you can go to the court for relief from liability. And of course, go ahead.
Now asking what section is that?
Ah, I wait for you all to tell me. Okay, hold on. Let me go in my Trustee Act. Morning. Let me see if I can find that in here. Okay. Section 73 gives them protection. If it appears to the court that a trustee, whether appointed by the court or otherwise, is or may be personally liable for any breach. Yeah, cancel it. You see it in 73?
Yes, power to relieve trustee from personal liability.
Mm-hmm.
Oh, yeah.
And the power to make beneficiary indemnify for breach of trust. No.
Yes.
That's one as well.
That's
74?
another one again, another defense, yes. And then go to section, let me see. I'm trying to see which one of these you can go to just to the court itself.
Maybe section 75.
75 says,
that says payment into court by trustee.
no, not the payment in the court. Go up to the 60s.
What about the trustee may apply to court for advice or direction? Not really.
Where were you? Where you got?
She's saying section 77.
77. Hold on. 77. Right there. Yep. Those are the two sections.
So 77 was one. The trustee may
Yes.
apply to court for advice or direction.
Yes.
73 and 77.
And 74.
And these are defensive mechanisms that trustees can use.
Yes. Now, another defense that he can have is he can, the trustee can ask for the court to impound a beneficiary's interest. Ask the court to impound a beneficiary's interest. So say the breach of trust was done at the instigation or the consent of a beneficiary, he can ask for the court to impound that beneficiary's interest. Instead of him paying all of the loss, he can have whereby the beneficiary pays a part of it.
And how does that work? Because if it's a breach.
It's a breach, but he did it in collusion with a beneficiary.
Oh.
Oh.
Oh, yes.
So me as the trustee made a breach in collusion with the beneficiary. And then the beneficiary turned around and sue me?
No, it won't be that one, it'll be another one.
Oh, okay. So then that beneficiary who is suing will be suing me and another beneficiary then?
Yes.
Okay.
So the funds that I would have given that beneficiary, would have given more, so that would have to be impounded by? No?
Yes, yes.
Okay, okay.
Or they'll impound whatever he's going to get next if he's already spent it.
Ah, okay.
So that doesn't prevent him from being a beneficiary moving forward. That just means that he has to pay out.
Exactly.
To compensate a part of what the trustee would have been losing.
Isn't this fun?
I started to feel like a trust officer now.
Yeah, but that's the purpose of coming to the class. And one more defense he'll have is lapse of time.
Lapse of time?
Yes. That means it's too old?
Yes. And every action has a limitation.
And what is the normal
6 years.
6
years. 6 years. Yeah.
Okay.
Okay, explain that to more for me, please.
So, in essence, a retiree is good or cleared after 6 years of retirement.
Yeah, because they want, but you mean because of a breach?
Yeah. Or is that only with recourse for
because there are
compensation?
Yeah, because there are some cases where there's no limitation period at all.
Right. So that's what I'm asking, because the breach may have happened now, but if the breach continues on, then that can still be proof. That would not. When does the 6 years start to account for? When it ends, or when it initially occurred?
When the breach occurred. Okay, let me find you the section. I hope they have it in here. Let me see, 20, maybe in 30.
Come back to that quick question, please.
Mhm. Go
Let's
ahead.
say a trustee is brought on the breach of trust, right? And the matter goes to court, and he wins his case to say, okay, he acted in good faith and what he did or whatever, right? Defense,
Mhm.
defense mechanisms work with him. Would he still be allowed to administer that trust, like be a trustee of that trust?
In most instances, but in most instances, sometimes the trustee would either resign or the beneficiaries then seek to have them removed.
Even though what he did was still good, they just want just remove that.
Yeah, because they don't feel comfortable.
Okay.
Now, and that's if that provision is made in the trust deed. If not, they have to go to the court. Let me
As it
see.
relates to the defense for the trustee, we
Mhm.
have referenced sections 73, 74, and 77.
Yeah, I'm looking for another one for you.
But what about the common law?
Oh, well, in common law, for the trustee himself, a defense in common law,
Yes.
I can give you many cases. I give you lots of cases.
I'd prefer one that's easy to read.
Which one you want? You want something under, let me see.
I want a paragraph.
Let me see. Let me see one. I'm trying to find who there's a paragraph is easy. Okay, so in the case of parents, Perrins, Perrins versus Bellamy, Bellamy, 1899, 1 Chancery, 797.
One chancery.
797.
Okay.
The trustees of a settlement mistakenly believed that they had a power of sale in the settlement and sold off some leasehold. As a result, the income of the tenant for life, the income for the tenant for life was reduced, and he sought to make them liable for his loss. It was held that in the circumstances, the trustees had acted honestly and reasonably and ought to be excused. That easy enough?
I think so.
Let me see. Okay, in the case of Reed Garnett, Garnett, 1885, 31, Chancery, D1. The court set aside a deed. The court set aside a deed, releasing trustees from breach of trust, which was executed by the beneficiaries at a time when they did not have sufficient knowledge of their rights and of what they were giving up by the deed.
Sorry, can you repeat the name, please?
Reed Garnett, Garnett. Mhm.
Okay, thank you.
All right. I mean, there are many, many more. Okay, so another defense that could be used, a trustee can be discharged if they are in bankruptcy. So if a trustee is made bankrupt after an action of breach, he will be freed from further liability.
And in that case, he can no longer serve as a trustee anyway, right?
Of course. He will be freed from further liability when he obtains his discharge in bankruptcy. Unless the breach was fraudulent.
So question,
Mhm.
for a trustee, I know that sometimes things happen. Once the trustee would have had a bankruptcy anywhere in their past, that means that they can no longer serve as a trustee, or is there a length of
No.
time after that?
No,
that they
long as you
can now
bankrupt,
serve as a
no,
trustee?
long as you bankrupt, no.
That's it. You can't
Yeah.
serve as a trustee at all anymore. Okay.
Nope.
So the settler does all that research.
But that's if you're looking for an individual. If it's a company,
Not a corporate.
yeah,
Okay.
yeah, not a corporate one.
Sometimes does the company goes bankrupt too?
Yeah, but if the company is bankrupt, they won't be open for business.
Okay.
Yeah. So the first thing you do is you go to the regulatory site and see if they're still licensed to do business. And then you could ask them to write to their regulator for their regulator to give them a letter of good standing.
Oh.
So in our case, that would be the Securities Commission,
Central bank.
Central Bank, sorry, yeah.
Yeah. So remember I told you all, when you all started, the first thing you should have done was go through the act itself so you could see all the relevant sections. Like the trustee has an exoneration in respect to certain things that an attorney does. So be good if you haven't done so, not for the exam, but just for your own edification is just to read what kind of protection a trustee has.
So this is just for our knowledge. not the
Yes, right. Because
Okay.
yeah, because once you read it, then you get an even bigger picture to say, okay, the trustee, if there is a breach of trust, there are certain protection that he has, but the protection had to be related to what the breach is.
Okay, and that's, would that be like the same section 73, 74, and 77?
Yeah, there are more. 35 is for attorneys. 36 gives the implied indemnity of trustees. And section 36.
Can you elaborate on that a little bit more? You say the implied indemnity of trustee?
Yes. So this is another defense that he can use. Under subsection 3, in section 36, it says a trustee may, upon resignation, retirement, removal, or otherwise ceasing to be a trustee of a trust, require from any continuing or new trustee or from any beneficiary a release and indemnity, holding harmless the outgoing trustee. So he could ask for an indemnification from any and against all claims, demands, actions, proceedings, damages, costs, charges, and expenses whatsoever. So that's another defense that he can have, because he can have an indemnification. If he had resigned, retired, or he was removed, he's no longer an attorney, he can ask for an indemnification upon leaving. And that protects them from any claims, any demands, any actions, any proceedings, damages, costs, charges, or expenses whatsoever in relation to the administration of the trust.
So if the beneficiaries had requested that he be removed, and there's no real reason, then it wouldn't be implemented. What I'm trying to get at is, if the beneficiaries requested that a trustee be removed, not for necessarily breach of trust, but for some other reason, and then later on they determined that there's some breach of trust that comes up after he's been removed, can they still go and sue him?
If he had gotten his indemnification?
No, if he didn't, because does it automatically come with that indemnification? If the beneficiaries decided that, okay, they want this trustee to be removed.
No, it's not automatically, because I said
so in the case where if they didn't give him an indemnity, or he didn't even ask for it, which would be silly. If he didn't ask for it, and the beneficiaries had determined that he needed to be removed, and he is removed, can they still turn around and sue him if they determine that now he's in breach like 3 years later?
Yeah, like I said, it depends on the breach. It depends on the seriousness of the breach.
And isn't a trustee automatically removed after, if they're, like, say they're out of the country, out of the jurisdiction,
Yeah,
for more than 12 months?
Yes.
Would that beneficiary be liable for some sort of breach?
That's more of a
Because he technically wasn't even doing anything.
He wasn't doing
removed
anything.
out of the jurisdiction. He was not entangled within the trust for 12 or more than 12 months.
Right, but don't forget now, the rule is a trustee is jointly and severally liable. So if he was not there, then the trustee, then the breach is on the one who was there, who did the act.
Okay.
So that one who was absent, they will just have to remove him and appoint a new trustee.
Yeah, but in terms of the liability, he would not have been there.
Yeah.
See, because don't forget now, what the beneficiaries will do is they'll bring an action against all.
And his defense would be that he wasn't here.
Right. His defense would be that he was not there. But it's like, if it can be proven that they had consulted with him and he had agreed, then of course he contributed towards the breach. And so there would be some loss occurred to him.
Mm.
So
that section right there is the indemnification clause.
So, Ms. Asha, quick question. Let's say, I don't know if that was what Robert was just asking. Let's say, trustee is now retired, but in reviewing the, let's say the books, the checking the minutes and all of that, they realized that he was in some type of breach. Can he be brought to some legal action? Now, I mean, even though he's outside of the trust now, retired, could they carry him to court for some type of action he was done?
Yes.
Okay.
The only way they will not be able to bring an action if it is a lapse of time. But a lapse of time, there's no limitation when it comes to fraud.
Mm.
Or if he took trust property, there's no limitation on that.
Sometimes you be wondering, like, man, the person that retired, how come they just,
Yeah, well.
how come they
That's
just get this person, or, you know?
Mm-hmm. You see, because don't forget now, that's with a trust. Remember now, when you are a personal representative on a will, you have similar duties. And the beneficiaries of that will can sue you too. That's also covered under the Trustee Act. When you read the Trustee Act, you notice it goes from trustee to personal representative.
Yes, ma'am.
Right. So you have to be very careful because you could be sued as an executor.
Wow. That's a risky job.
Yeah. I think you would have seen, if you read the papers this week, you would have seen Camp on East Street. That own all of those buildings on East Street just before you going up the hill.
Okay.
I see where there's a notice put in the paper. If anybody have any claims against the state. And that matter's been there a very long time. But don't forget there was a lot of dispute.
Wow.
Okay,
Well,
so
Ms. Asha, I was reading in my studies this week. When I came across continuing and surviving trustee, right?
mm-hmm.
So basically, that's just a trustee. Let's say, okay, some of the trustees have already retired, or worst case scenario, died, and the last surviving one. That's when they are appointing other trustees.
Yeah. So that section, when you see all of that about continuing trustee and last surviving trustee, so they're talking about when the trustee is it could be an individual or a company. You would see that more where you have individuals, or you can see it when you have a personal representative.
Yeah.
So it's like upon death. So if you were the trustee of a trust, and then they have to look to who is the trustee of your estate. Because the trustee of your estate will now have to continue on to finish what you didn't finish. They have to complete it. Yeah.
So why would it not go to the courts for the courts to just assign a new trustee?
No. Under the law of administration of estate, it continues. If you want to be rid of that, you have to go to the court.
Wow.
That's why it says continue and continue and continue. It continues on until there's no trustee.
Or the beneficiary could just sue to get their stuff to them, eh?
What do you mean? Sue
So
in
that
order
they
to have it
could close the
administered?
trust.
Yeah, that's from a pure trust side. But the question she was asking about that continuing trustee,
Okay.
that's more on the
trustee side.
under the administration of an estate, when you have an executor or personal representative who also acts as a trustee. Yeah, because the court can appoint a trustee. They have the power to do that under Section 49 of the Act. Let me see. Is a trustee liable for the breaches committed by his successors?
Yes and no.
Ah, very good. Yes and no, correct. Everybody get that?
He's liable to return of a successor.
Say that again.
No, I repeat
Oh.
the question you were saying, and then I listen to
A trustee is not liable for the breaches committed by his successors. True or false?
Say the question again.
A trustee is not liable for the breaches committed by his successors. You answered it already. I want to make sure the others get it.
Yeah, technically it's true. However, if he had knowledge that something was going to happen,
there you go.
Then
So
he would.
if that was a true or false question, that means whether we selected true or false, we would get it right?
No.
Because the answer is yes and no.
So that statement is false.
Okay.
No, but I thought let's just say if a breach occurs or during the time of the previous trustee, right? And it's an act that he should have identified but didn't. And when it came down to the successor trustees, it actually occurred or it should have been flagged during the previous, when the previous trustee was involved with the matter.
He's not liable in most instances, but if he knew at the time when he was retiring that the likelihood of the breach was going to occur or continue, he is liable.
Likelihood. Okay.
Yes, likely to occur. And I told you to read the case of Head versus Gould. I think let me see if it's online in enough detail. Otherwise, I would have to send it to you.
Doctor, you sent us the questions this week?
No, I'm sending it to you now. I decided not to. That's why I give it to you right now. I decided not to send it. I said no. Okay, this is short. Let me hold on now. I see it on Wikipedia.
Oh Lord, I don't trust that site.
No, I made it short. It's short.
Okay.
Okay, so that's one there. The Head versus Gould is there. I was trying to see if I could find a longer one. There's one on, Schwab one is very small. That's a short one.
Are you a trust officer?
Oh, no.
You've never worked in trust?
I worked in trust at Scotia Trust.
Okay. So,
but not trust every day. No. I studied trust law in law school.
Oh, okay.
So you are a lawyer?
Yes, ma'am.
So
Yes.
based on your when you was working at social trust, can you say like a different type of I don't know if that's a question if it's the right question to ask, but what are the most common trusts you saw people open or I don't know if I'm wording it right.
Yeah, it's discretionary.
Discretionary, okay.
Discretionary trust. Most of them are discretionary trusts. Because that's the whole purpose of going to a trust company. You don't want to have the headache of those assets anymore.
Mm.
So most of them are discretionary. They could be for charitable purposes or they could be for the benefit of the beneficiaries. Okay, I see there's one here typing it. It's one on YouTube. Head versus Gould is on YouTube.
Okay.
So it's youtube.com/watch?V. Yeah, they're typing it out as I put it on here and it's just going. All right, so that is breach of trust. Now, let's talk about our exam.
Dun, dun, dun.
Huh?
I say nothing.
It's not that bad, man. Come on. Y'all knew this time was coming. You all were excited a few weeks ago. Oh, man, hurry up, come.
I think it was excitement.
That's what you say.
We just was nervous from then.
Yeah.
Okay. All right, so the exam has two parts. Part A is mandatory. 2 questions. Answer both. And part B has 11 questions. Answer 6.
The part B has 11 questions.
Mm-hmm.
Uh-huh.
Answer 6.
So those are 10 points each on those parts then.
Yes, 10 points. And always remember, answer each question on a separate paper. Don't put 3, like if you were answering question 3 and question 3 was halfway down and you put 4 on the same paper.
Okay.
It's very difficult to mark. Write them on separate paper, each question. Okay. Let's see, where should I begin?
What is the part A? What is the question? The 2 questions that are mandatory. I mean, what's the question would be based on?
What? I can tell you.
Okay.
We're starting with the long one first. We're starting with the one where you have to choose. Okay. I think we did this one last class.
Investment?
No. When you're transferring a trust, you need to know what a trustee needs to consider. There's a question on different types of trusts. So there's 2 questions gone.
So with the one with different parts of trust, are we explaining what the trust is, what the trust do?
No, different types of trusts. We did that question already in class, remember?
Yes, ma'am.
Okay.
Okay.
You mean like discretionary, different types of express trust or different types of trust on the whole?
Trust as a whole.
Okay.
We did this one last class. We spoke about the trust administrator.
Okay, and their duty is right.
Mm-hmm. But in this question, you're gonna write for me a job description.
Yeah.
Job description.
Of the trust administrator.
Mm-hmm. There's a question on certainty of trust.
The three certainties.
Mm-hmm.
I guess we'll have to list them and then elaborate on them.
I'm giving you some quotations from wills, and you need to tell me where the trust was created.
Okay.
You need to know what a court would consider when it's going to appoint a new trustee. You need to remember when we were doing the accounting section, and at the end I told you, you have to know the difference between appropriation and advancement. Okay, that's a question on that.
So question, as it relates to knowing the difference between appropriation and advancement, would that be one of the questions where we can do a chart? Seeing as though we're giving, I guess, comparisons?
This isn't a comparison, this is an explain.
Oh, you want us to, okay.
Let me see. Let me see. Remember a trustee under the act, he has the power to employ agents and also delegate some of his duties. You need to discuss that.
Said empower to employ agents and
Delegate the duties.
Okay, thank you.
There is a scenario question on a trustee exercising his powers. There is a very short question on when a trustee may be appointed as a replacement.
When a trustee might be appointed by a replacement.
As a replacement. You should know the reasons why a person would want to establish a trust in the Bahamas. And when we did the chapter on beneficiaries, remember, I told you that No beneficiary has a proprietary right to information concerning a trust. So I give a quotation from a famous case, the one you should have already read. I told you it's online and you need to comment on that.
The Relander. Yeah.
You remember the case?
The Relander. I can't remember. Oh, yeah.
No.
What is
was the
it?
case? What was the case?
Say the question again, please, Ms. Archer.
The question was, remember when we were discussing beneficiaries, that chapter?
Mhm.
And I said there's a comment made that no beneficiary has a proprietary right to information. We discussed a very important case. And I said, make sure you go home and read it.
Smith versus Rosewood.
Yes.
And then Smith versus Rosewood.
I ain't saying nothing else.
Then Lord. Okay, so what the question is?
But Ms. Archer, this ain't the exam, so you could tell us so we could properly prepare. You want to do that first?
You were in class that day, right? We only discussed one case.
I was.
Okay.
We discussed many cases, but that one is the one we discussed in detail. Y'all, okay, so it's Smith versus Rosewood. Okay, Ms. Archer, don't have to confirm.
Thanks. Okay, so what if we say no some beneficiary in that case?
She also said that that case covered the other two cases that was relevant to that topic.
God bless you.
Thank you very much. They need to listen.
Man, I get so much different cases going on in my head. You think
Listen, Olivia. Listen, Linda.
Focus.
Smith versus
focus.
Rosewood covers the other cases because the other cases are very old. And Smith versus Rosewood was in 2003. And so that is the one that has the most relevant information. And it covers why the other cases are no longer relevant. Like it touches on all, she said it touches on all the other cases.
Okay.
And I did say read it, right?
Yeah.
Okay. So if you count, you have 11.
Yes, ma'am.
Okay, now let's go to the 2 mandatory questions. Let's see. What happened? What you calling the Lord name for?
Because I feel like you going to give us investments or something like that.
Of course.
Why that can have been optional?
What? No. Investment is the main activity of a trustee. Why would I make that optional? No. No. Never. I'd be derelict in my duties in doing that.
Okay.
Gotta know the main thing. Now, this question is worth 20 points. And what I've done is I've given you the corpus of the trust. You know what that means, right? Okay. And
repeat that again, please.
The question, the mandatory question, one of them is I've given you the corpus of the trust and I want you to answer 2 questions on that corpus. Now this question regards investments. And so you should know the sections in the act that speaks to what you should take into consideration when you are investing. So if I ask you to invest in a narrow range investment, what do you think that means? When I say a narrow range.
You're talking about something that's risky?
No, not really risky. More the opposite. More conservative.
What is a straightforward investment?
Yeah, straightforward one. So I'm asking you, based upon what the corpus is, would you change anything? But you do know that before you begin the question on investment, before you give an answer, you have to speak about what you need to take into consideration in general when you are investing. And then I ask you the question, what if you had to do the investment in a wider range? What would be your considerations? What would you change?
So the narrow range would be a straightforward investment.
Yeah,
Wide
safe.
range would be more of a riskier
Yes.
type investment.
Uh-huh.
So would that be an investment where you would have more things to consider?
Well, that's up to you. You tell me. I ain't going no further than that. And of course, the second mandatory question is on breach of trust. And it's a scenario also. And I know you all will tear that one and eat it up.
I admire your confidence.
Well, first, you're going to talk about what breach of trust is. You're going to speak about instances where the beneficiaries can sue. Then you'll narrow it down to what you think this one is. And then you're going to say whether or not the beneficiaries will be able to prove breach. And then, of course, you would include the defenses for the trustee, if they have any, and conclude.
I think I can see some of the light at the end of the tunnel.
Now, don't make the mistake where your 10-point questions are longer than the 21. I've seen that happen, where students like a topic so much, they write 2 pages on the 10-point question. And when it came to the 2 mandatory questions, they give me half a page each. To make sure you have your time allotted properly and that you have the information you need for the questions you're going to answer.
So it makes sense to start with your mandatory questions.
Mm-hmm.
And get that out the way.
Right.
And then work on your
10 points.
optional ones.
Right. And you should know before you go in what you're going to answer. So even if you say, I'm going to look at 7 or 8, and when you get, because sometimes I'll tell you what happens. Sometimes some students only study 6. And when they get an exam, when they look at the angle the question's written from, oh my God, I don't know the answer to this. Then they go and they try another one, then they try another one. So make sure. So I don't think that's too hard. It's relatively easy question.
Please don't use so much big legal words.
Where?
I don't have heart palpitations when she says she can reference the thing from the trust deed itself, because that's when they can come with all the legal jargon.
Yeah, I try not to do that anymore because I see y'all start panic too much. So
that just threw me off bad.
Yeah, so
I ain't gonna understand by the time as I reach the end of that.
Yeah, you'll have headaches.
Yeah.
Okay, so I just gave you a quote from a case this time. I didn't put that section in. I was going to, but I changed my mind.
Appreciate that.
Yes. So what I did instead was on an investment question. I just tell you, you have to refer to the act. So study the sections in the act to deal with investment, because that's what you're gonna have to use. Because if I had done the clause, you know, first the clause was going to be long, and then you're going to be confused. By the time you got to the question, you can give me a funny answer. So I say, you know what? Let them stick to the act itself. It makes it easier. All right. So your exam is April the 4th.
What now?
And your exam is April the 4th?
No, ma'am.
April 10th.
Oh, it's the 10th. Oh, I put the wrong date on this.
Gotcha. Don't do that.
What?
I seriously put the wrong
Please
date
don't do
on
that.
You want me calling sick for the weekend?
Why put the 4th?
I'm already-
Hold on, let me go back.
I'm glad you mentioned it so that we can all be on the same page.
Yes, hold on.
That's no
I
need
need-
to change the questions now.
No,
Uh-uh,
yeah,
uh-uh.
just the date.
No, I just changing the date. It's a good thing you said that. I said on the 4th, that's the holiday weekend. I said, wonderful. Hold on, April the 10th.
So
Okay,
next week
change that.
Saturday is just revision.
Where you see that?
Hold on, let me look at what Beth wrote. Oh no. Oh, that's
No,
no
we're
more.
done.
That's no more. Sorry. I thought I had more time with you. Sorry.
No, you don't.
Sorry.
Focus, focus, focus.
Okay.
Focus, focus, focus.
April 10th.
Yes, I changed it to the 10th. I have the 10th on the exam now. You all happy? Yes?
Very.
Okay, all right. So study hard. Don't panic.
Question, as we get closer to the exam date, you'll give us the time.
Miss Dean, she'll send it to you.
Okay,
The office will send you the time.
okay.
It's normally the same time as class.
Oh,
That is
okay.
Saturday, right? Yeah, it'll be from 9 to 12. 9 to 12. Mm-hmm. Yeah,
Will
so
you
that
be
should
there
be.
that morning of the exam?
No. If I'm gonna be there,
Huh.
no, I get the exams after you're finished. What you need me to be there for? Let me hear this. Let me hear this now.
You know. I don't know.
No, you'll be there. When you look at the exam, you'll see there's no surprises. No surprises at all.
Have mercy on us when you mark it now.
What that means?
Well, the rest of them make, have mercy on me. Let me.
Have mercy on you.
Yeah, write my name down on the have mercy list.
Yeah.
Yes.
I have two friends who have done some courses that you taught. And they both said, you're a really good teacher. They get that out of the way. And they say you like detailed answers.
Of course. That's the only way I know that you understand. That's the only way. Remember now, when you finish this section and you move on to section 2. So when you move on to section 2, there's no repeating what's in section 1.
Oh.
So it's expected that you will build upon what you already know.
Is section 2 hard?
What that means?
Oh Lord. It's okay. I know it's gonna be more complex, but so based on our knowledge in part 1, everything should be able to flow in part 2 then.
No, part 2, you can learn something else. And you'll add it to this. Mm-hmm.
And this, the way we are taught now, this is like this in the Bahamian text or the British text or the American text.
No, this is British.
So part 2 will be British as well.
Mm-hmm.
Okay.
Especially for trust, we don't use a lot of American reference.
Okay.
I normally do it some sections in part 2, I would normally compare the business trust that the Americans use against our trust. So when we look at different products that are used internationally that compete with the Bahamas, the Americans have their own idea of what a trust is. Canada also, but it's not the same.
Okay.
So
Yeah.
stage 1 lays down the foundation of what
Trust law.
trust law is about. But what does
Yes.
the second section cover?
Oh Lord, I just know you're going to put me to work.
You're not teaching that section, Ms. Archer?
Probably at the end when it's time for you to take your exam.
Oh,
What that means.
you say at the end, that's the part when you come drop the ball.
Well, now you know, right?
So it's broken up with different teachers like the way this one was too then.
I'm either at the beginning or at the end. So part 2. Part 2 has 2 parts. The first part is on company law principles, and different types of companies. Then you do company incorporation, company management, corporate record keeping, client due diligence. Then you do company compliance and managing risk. And then you'll do corporate secretarial practice and liquidation. Because remember now, when you operate a trust is at the top. And then underneath the trust, you have companies. So this section is looking at companies. So that's part 1 of part 2.
What do you
Part
mean
2, go ahead.
when you said the trust is at the top and then underneath is the companies, meaning that the trust owns the company?
Yes.
Okay.
So part 2 of part 2, you would do the duty of confidentiality, trust documentation, trust policies and procedures. You'll do the protector. A little bit again on trust investments and accounting because it's important. You look at some special assets and asset protection. Then you'd look at money laundering, and then some special trusts that are established by Bahamas, the private trusts and purpose trusts and charitable trusts. And then the last class would be your revision. And if there've been any amendments to either the Trustee Act, Company Law Act, or money laundering, purpose trust, any one of those. If not, then it's just the revision. So that's what part 2 is about.
So at the end of the second class, you'd actually be you would be able to fully function in trust then.
Yeah, at the beginning stage, and then you can move on and you can take the exam you can start to study for STEP.
I hear that exam don't play. But Ms. Audrey, what is this course we done? The part 1 part, wouldn't that be equivalent to a part 1 from the paper 1 for STEP?
Yeah, I think there's an exemption that's allowed.
Yeah, and then we just look at focus because I think it's 4 parts, right?
Yeah, and you get an exemption.
Yeah.
How long
So that's
is
why I have to make sure that you know it.
How long is the second stage 2?
6
Stage
months.
2. Let me see, September, October, 3 to 4 months.
Oh, okay.
It normally runs from September to December
Oh,
with 2 exams. So what we'll do is we'll run part 1 again in the summer, and then you put the 2 classes together. Because sometimes a lot of people from part 1 don't want to do part 2. Once they've done part 1, they finish. That's enough. That's enough trust for them. Then you have some people who want to move on.
But then, like, they'll just get the certificate. They won't get the diploma.
Yeah, when they get what they you get what you what they say you get what you buy.
Okie dokie.
Yep. So I don't think the exam is that bad. I could make it a little harder because you all are rather sharp.
Yeah, fine. No, just leave it just like that.
So you say.
I won't be able to go back and say, man, that exam, I eat up that exam.
No.
I will be, dreaming about, failing.
Yeah, you will be dreaming now. I know some students who go on the exam, they write 1 sheet and that's it. They say they went blank. And then when they come, yeah, some people go blank. And then when they came, they could riddle everything off. They say they remember when they got in their car. This is a little bit too late then.
I think I'm
like
have a breakdown. I hope that's my fear, I fear that if I go on an exam and I just can't remember that. No, I can't know how to put my words together.
Well, you have until April the 10th to get your mind together.
Yeah.
So get it together.
That's why it's like those you with them big words, no question. Well, you just sign my name on that paper and go sleep. Because that'll be so long.
Well, I hopefully hope there's no big words on the paper. I don't think so. I wrote another exam this week and they said the same thing. Don't put no big words. So I tried not to put no big words. I made it as simple as I could.
You teach compliance, right, Ms. Arthur?
Yes, at the end.
Okay.
At the end. Sometimes at the end, sometimes at the beginning. Hardly in the middle.
Okay. So do you do all the levels of compliance or a certain level you do?
Oh, you mean at BIFs?
Mm-hmm.
No, I don't do intro and intermediate anymore.
Okay.
I just do the ICA part. I write the manuals for them, but I don't do the classes anymore. But that's also a good one to do.
Compliance?
Yes, it's good to have it underneath your belt.
Where I work, we must see this do. Oh Lord, must see 5 or 6 AML workshop training courses or something like that. Like a lot.
Why?
I don't know. Like we always doing like a refresher course or something like that.
I don't think you need that many. You only need one.
Oh. They always talking about the same thing of fishing, smishing, all that.
Yeah, but it don't make any sense beating the dead horse. You do it from different aspects. There's a lot of different things you can do. But then it depends on the client base and what they see happening. But to say keep doing the same thing over and over again, that means what? You all failing the quizzes?
No, it's just be like little video showing like what to do in the office and what not to do in the office. Like knowing what emails to avoid, knowing to protect in your workspace, knowing to carrying your ID badge and locking your computer and all those.
Oh, that kind of little thing. Oh, okay. Well, they ain't talking about the real compliance issues.
They did it before too. But that one is not repeated as so much as the little
That's
mini.
the all. Okay. So they've probably seen a lot of breaches.
I get
Ms.
it.
Archer,
That's operational. Go ahead.
I have a question. With the
Mhm.
mandatory questions, would we have to refer to law as well as common law?
Now, don't forget now, when you mean for
We
yeah,
have investments and
yeah,
when we have breach of trust. Would we
yeah,
need to make reference to statute law as well as common law in the question?
yes,
Okay.
yes, you do. Isn't it wonderful?
Oh, okay.
You all know, you. I think you all knew you learn a lot from this class and you find it exciting. So try not to deny it.
We're not in
What's the
denial. We just
What's
don't know how the question is gonna come.
What you mean? I just told you how it's coming.
Yeah, but you know, like you told us before, you're persons who read the question and then they write everything that they know except answering the part of the question that they really should be answering.
Well, that happens a lot.
See, we don't want that to be us, so we on the
And I
edge
think
now.
and that is because they probably didn't understand what the question was asking.
Mm.
And so I'm
No.
trying to figure out how I could make sure that I might could answer the question, but I need to answer the question that you ask.
There you go.
And so that is my fear. Even though I might have the information, I need to pull the right set of information that needs to be
right
answered.
I agree with you. Because I just did one on exam. 2 persons answered the question wrong. Totally wrong. Totally. I don't even see how they got on that road. But they was on that road. I couldn't see it. Some just left it blank.
You had
It was
given
a
us
multiple
a question a while back, and that had me lost.
Don't worry, you won't get lost.
The one where you told us you had provided a quote.
Right.
And, like, after I read that quote, I didn't know what to go. I had no idea how to answer that question.
But the quote on this one here, even if you say you don't know it, you should know it. Because I already told you all to read the case. I gave you 2 cases to read today. Did I not? 2 cases. One before we started the question, the exam, and one during the exam review. What's the case I told you to read? The first case.
Head versus Gould.
Okay. And then when we did the revision, which class did what case I tell you to read? That I told you to read from last week.
Smith versus Rosewood.
Okay then. Oh, okay. So you know off the top of your head, those 2 you must know in detail.
Okay.
If you want to answer the question in part B on disclosure, you need to know that case. If you do investments, what cases you need to know? Fight versus Gowan versus Cargill, Nestle versus Westminster. And then you need to know the sections, not the sections by number. You need to know what the sections say in the Trustee Act under part 2.
Oh, so we don't have to say section 23.
No.
We just need to say what section 23 was all about and what part of the law reference, what the law says that we need to.
Yes.
Oh, okay.
So if you were doing the defenses that are available to a trustee, you would say the Trustee Act provide for 1, insurance, but it doesn't cover breach of trust. 2, in your own words. I don't expect you to remember. Section 73, 74, 30, 21. No.
Okay. That helps a lot.
Yeah.
Just need to know what the law is.
You know what the law is. Yes. So that's, yeah, I don't think it's hard. I don't think I have any difficult words in there. I think
That's because you
Okay.
know the law.
oh Lord. I trying to teach you all this. Okay. Yeah. I don't think it's too bad. I try to make the questions as simple as possible for the same reason. So just answer the question that is asked. Yeah, okay, it's good to go. I don't see no other changes I need to make, except for the date. Okay. I should have put on your answer each question on a separate page because you all tend to forget. Even though when I write it, I still do what I feel like doing. Okay. Answer each question on a separate page.
We need to
Okay,
bring
I
a
have
piece
that.
of paper and everything.
No, just bring your pen and your mask. That's it.
Okay.
Nothing
Coffee
else.
with us?
Hmm?
We bring a cup of coffee?
Yeah, yeah. They won't check that. They won't check your coffee container. Bring your coffee, bring your water.
I don't drink coffee, but I think I can need some that day.
Oh, so you can bring tea.
I can need me something to keep me alert. I can need that
Yes.
coffee.
It's 9 to 12.
Miss Archer,
Uh-huh.
the year is important.
Oh, what? For the case?
Yeah, if
No.
anyone references, no?
No, no.
Oh, okay.
See, it wasn't that bad.
Because I was remembering the case where they keep forgetting which year it was made.
No, no.
Ms. Archer, you were saying that you would send us that case? Or that's what you just said, that we need to look at it on the one on YouTube?
No, I said there's one on YouTube.
Okay.
Yeah, it's been typewritten. It's just a shortened version. But you should be able to find that. Head versus Gould.
Okay.
Yes, not that.
Thank you.
That should be good.
So it's a good thing I asked those questions in relation to that because that wasn't even referenced in the book.
Oh, no, it wasn't. But the statement with regard to trustees and when they are liable for breach of trust even after they retired, that point is there. Just
Yeah.
that in the exam, you would have to figure it out.
But that's what I'm saying, that the case Head versus Gould was not mentioned in reference to that.
No,
So the reason we're reading that now is to make sure to provide us more insight on how to answer that question there.
Yes, ma'am.
Clearly that we have to refer to that case.
Yes, ma'am.
Oh, okay.
And so, for those who decide not to read it, they're gonna have to figure it out.
Oh.
So if you're answering a question on breach of trust, how do you approach it? If you have a scenario and the beneficiary is suing for breach, how would you answer that?
Don't we need to say what the breach is?
Mm-hmm.
And
But before you say what the breach is, you have to introduce by saying, what is a breach?
okay.
Then you could say what the breach is. And then after that is what? What you talk about next?
You could talk about the instances when the beneficiaries can sue.
That's the same thing what I just told her. But you're
How
missing out
about,
something.
how about when writing the answering the question? Okay, we give the definition of what a breach trust is. Would you like? What about referring a case into the question, like reflecting back on a case?
What you mean?
Like if we're describing, like based on what the question is, or that you're asking of us, and we're
Uh-huh.
answering the question, we give the origin of it, and then we could probably in writing in explain that we could reference a case.
Yeah, you could. Yeah.
You can reference
You could always
what
you
the
could always add a
duties
case.
are,
Say it again.
the trustee's duties to show that this, and then to say which one of them that he is breaching.
Yes. And then you have to say what the breach is,
Mhm.
but you're still missing out something. Let's go. You have to be able to say what are the remedies that are available to the beneficiary, remember?
I don't say that. The defense.
No, not the defense, different from the remedies. As a beneficiary, you're looking for remedies, remember? Injunction. Or you want to bring an action against the trustee for the loss. Or you want to get a proprietary remedy where you want them to recover the funds, the property. Or you could bring an action against the other person who received the trust property.
Do we have to mention all of them, or just the one that would be relevant to?
Appropriate, relevant to the scenario.
Okay.
And then, of course, the trustee himself has defenses. And we went through all of those defenses. The defenses under the Act. He has a defense if the beneficiary would have consented or participated in it. He could ask for the court to impound the beneficiary's interest if the beneficiary had a part of the funds. Next one would be lapse of time. If it took too long, but there are exceptions.
Mm-hmm.
And he could be discharged if he's found to be bankrupt. And he can also split it if it was more than one person. So it's called contributory, it's contribution, just his part, because remember, trustees are jointly and severably liable. That leads you towards getting at least 17 out of 20.
What if I want 20 out of 20? What I need to put in for the last three?
Your cases,
Sorry?
your cases and the sections under the Act that
Okay.
we went through today.
Okay. So then I would actually have to mention the section.
No. You say provisions are made under the Act in particular, and put a semicolon 1 and summarize it.
Ah.
I don't need you to memorize the sections.
I will not be able to memorize the section.
Yes.
I can probably reference it and talk about what that section talked about.
Mm-hmm. Yep. So.
We're gonna make it, guys. We're gonna make it.
Of course, come on, it ain't that bad.
We're gonna make it.
No, not that bad. Not that bad. Come on, it's easy.
Like how you give us what exactly is gonna be on the exam. I feel a little bit of burden off me because before, like this week gone and last week, I was trying to study everything, remember everything.
No. What I told you to do is go start going over the book again. And so when I tell you what's coming on the exam, you know exactly where to go in your book and make your little tick or your highlight.
Yeah.
Okay. There's no need to get all like frantic.
For the 11 questions you gave me, I confident with like 6. So I have to, go back over and look at some I might not be sure with.
Okay, right. Yeah. And for the 20 point, you have to give it your all in all, but you better answer the question.
Yeah, that investment, that alone, I gotta go for that too.
Yeah, so, and then you need to put your cases in.
See,
So
Ms.
if you
Atkins,
didn't
I'm
look,
not a long-winded person when it comes to writing. I like to answer just what the question asks me.
yeah, agree. Don't go all over the place now, because if I start reading the first page and you decide you can put the answer on the last paragraph in the second page, won't work.
I want to like I have a half a page or 1 page, but I just want to hit the points.
But then
Like,
that's what I'm saying. If your half a
like
page
one
hit
out.
all the points that I mentioned, then it's fine. Some
Okay.
people take a long time. They are mentioning the points, but they're long-winded.
I
Some
know,
people,
I know.
right? Some people just lift everything from the book, and then just by an order of lifting, the answers at the very last paragraph. But you don't get nothing for the first part because it's not relevant. Answer the question that is asked. So it depends on how you write and what you write. That's it. That's it. It's not that difficult.
Do you have where persons finish the exam like in 2 hours versus taking the whole full 3 hours?
Yeah.
Okay.
If you come prepared, then you don't have time to waste. But if you're not prepared, then you're going to be sitting there trying to figure out which one should I do next.
Oh, you could probably just be taking your sweet time. Like, you don't want to rush. You want to just, use the whole time allotted for.
Mm,
Yeah.
okay. If you say so. I figured you come in and do what you have to do and leave.
Yeah, but you don't want to rush, and then when you're driving, you'd be like, oh, I put this. Oh, I forget that.
Okay.
Yeah,
If you say so. I just like to walk in, write the exam, and walk back out.
That's me.
That's half an hour. That's what it is. It's 3/4. That's what it is. But I ain't sitting there to the very end. What don't come to my head at that very moment, that's it. I am not trying to recall that. So what I normally tell students I do, as soon as I walk in, the paper that's in front of me, I write down everything in my head that I need to know.
Okay.
And then as I write, I can just refer to that sheet that have all my little notes on it. That's the first thing when you say turn over the paper, I write down my notes. Then I read the question and then I take off and start writing. Yeah. All right. So enjoy your Easter. Study hard.
Yes, ma'am.
Hard and smart. And I'm looking forward to seeing some good A papers.
Oh, one more question.
Go ahead.
So, like, so let's say you don't mark all the papers. How do you distribute our grade? You just email us and be like A+, or like, how do you do it?
Miss Dean will call you.
Oh my God. She is calling.
But once I mark it, the grades go into the office. And then she'll tell you whether you pass or you fail. If you want on the grade, I'm sure she'll tell you. And
So
if you fail, then she'll tell you what you need to do next.
This class is just either you pass it or you fail it.
No, there's distinction in merits.
Okay.
But the first thing everybody want to know whether they pass or fail, because they need to know whether they need to take the exam again.
And let's say, God forbid, knocking on wood, let's say you do fail. Like, how fast could I get another exam out to take?
It depends how bad you failed.
You'd be able to retake it like in a week or so, or something like that?
Yeah, if let's say you fail miserably. Sometimes depends on how miserable your failure was. I would tell them let you sit the same exam.
Or you miss 2 points off.
I'll write you a new exam. You get a brand new exam. But it depends. When I read the paper, and let's just say I say you 2 points off, And I've already given you as much points as I could give you. I've looked all through again. I don't see any more. So you're only 2 points off from that. It depends. I could give you a 1 scenario question to do.
Oh, okay.
Yeah, it depends. It depends on how you feel.
So that'd be a conversation with you and that person.
Me and Miss Dean.
Okay,
We'll just tell you if to come and sit the exam over.
okay.
Yeah. But don't need to worry about that now. You all will pass.
Yeah, man, we got this.
You all will pass. In case they just read the question. And then you can go from there. It ain't that difficult. Not at all. Unless you want some more scenario questions.
Just leave the exam. Just try it.
You sure?
Let's not
Only if
add.
you
Let's not
answer the
take it.
questions, like instead of having 11, you give us additional, but you leave it where we only have to answer those same 6.
Unless you want to do a bonus question that we could take on, and that could be scenario. And
There's
that
no
could probably-
bonus. There's no bonus. No, you don't need a bonus.
Okay,
What
then.
for?
Okay then.
No need for a bonus. Okay, I'm sending this exam to the office now. It's done. It is done. I'm sending it right now. April the 10th. I've changed the date so you all don't need to die. All right, so we're good to go. Enjoy your holidays. Please study. Don't wait until Thursday night. On the 8th of April, decide that you want to start to study. All right?
Yes,
So you can
ma'am.
start now with your notes, especially for the mandatory ones. You just had class, you should figure out now how you're going to answer the 2 mandatory ones. And then you could pick your 6. And from the 6, work out what you need to know in order to get those points. All right?
Yes, ma'am.
Okay, so enjoy your weekend. And on Monday, get started preparing for your exam.
Yes, ma'am.
Okay.
Thank
All
you.
right. Talk to you
Thank you,
later. You're most
everyone.
welcome. All right. Bye-bye.